there. On today's episode, I want to talk to you about how to win in court. I'm Catherine Christensen, and I'm a family law lawyer in Canada, and I have lots of time on my feet, all the way up to the Court of Appeal. So I know what I speak if you want to have some insider tips on how to maybe represent yourself in court and win. First of all, keep everything in writing. You need to provide the court with solid evidence of why your claim on the issue is granted in your favor. The best method of this is to have documentation that backs you up and is included in your affidavit or presented in a hearing with witnesses. It's important that if you're going to speak in a chambers hearing that isn't a formal hearing with witnesses on the stand, that what you want to talk about is in your affidavit, because if it's not in your affidavit, the judge can't take it into account and often won't even allow you to present it. Number two, if you have an ex who will twist everything or deny ever saying something or likes to make faces and gestures, then the extra money to have questioning done with video as well as in writing with a court reporter under oath can be very useful. Your ex can hardly deny saying exactly what was recorded or deny attempting to hijack the situation with faces or body language when it's clearly shown on video that they were making faces or at you. That may not show up, that doesn't show up in a written transcript. It does show up in a video recording of questioning. Number three, focus on your own case. Don't worry about their case. Focus on your case. You'll see lawyers who lose their cool in the courtroom. You'll see them throwing pens and papers trying to make their point. It doesn't work. You'll see your ex try to distract or divert attention with drama or even outright lies. Don't react to any of it. Go in with clear notes of your most important points that support what you are asking the court to give you. It's vital that you walk in with written notes clearly documenting to yourself what you want to say to the court, so it comes across as professional, calm, here's what I want, and this is why. The person on the bench has seen it all. Believe me, they've seen it all. Your ex may think they're throwing some new twist or they've got the secret. They don't. Justices on the bench have seen it all. And they know very well that your dramatic opponent is using tactics that often are only to support a weaker case. 4, document every little detail and moment. I've talked about this before. You need to keep solid evidence in order to hold them accountable. No conversations in person. Again, no meeting up at Timmy's to chat and work things out. You want to be able to pull out an email. You want to be able to pull up a text message. You want to be able to pull out a bank statement that shows that, yes, you did pay your child support. You want to have those records. Every single payment of money that goes in and out of your account regarding your ex or the divorce needs to be recorded. Have it all, and then have it with you and ready to give to the court. Number 5, do your research. Thoroughly research. Know how the court decides these issues. Know what the legal test is for the question and meet every one of those steps. When a lawyer looks at case law, what we're looking for is what's called a legal test. So if you're interested in presenting an offset for child support because you've got shared parenting, so you want your ex's income to come into account and you pay less child support, then you need to look at the cases that deal with set off of child support, and in it will clearly show what the judge used to make that decision, and make sure you've got yes, 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 and yes. Give it to the judges that way. That's how they're used to hearing it from lawyers. They'll respect that you've done your homework and that you're presenting it to them in exactly the same way. Do your calculations. If you're going in on a child support matter, there's a free child support calculator called mysupportcalculator.com, which is basically the free software that I pay for to do child support calculations for my clients. If you're going in on property and you need to show values, then walk in with a value. Do you have something in writing that shows how much the house is worth, or how much your car is worth, or what your RSPs are worth today. I would even advise, our courtrooms are public. Justice is supposed to be an open book in Canada unless the judge seals the courtroom for some reason. I'd recommend that you go to your local court and sit in the gallery and watch family law chambers or docket court in a provincial matter, so that you can see how lawyers present their evidence. You can see how judges react to certain actions and certain presentations by lawyers. This is how you learn. When you're a brand new lawyer, as I was one day, it used to be, my key asset was that I was watching the judge and watching how the judge was reacting to what's going on in his or her courtroom. How are they reacting to how things are presented? And it's on the record, I've got justices praising me for my presentation because I didn't lose my cool. I presented the facts, and I presented what I wanted and why I should get it, and here was the test, and my client meets every one of those. I don't have to get into a shouting match. I don't have to throw my papers around the table. I don't have to have, doesn't matter if the opposite party starts to cry. It doesn't matter in law. What are the facts? What's your evidence? And what do you want to get? Which leads me to keep your cool. I know, even as a lawyer, that there are times where I am listening to the other lawyer in the courtroom present what they say the facts are, or actions they say I have done that I don't really agree with. And sometimes it can be really hard to sit in my chair and let them speak, because I'm going to get a chance to speak myself. Even if I'm the first one to present my case and the other side goes and says a bunch of stuff, I'm writing notes. What are they saying? What's my response to it? Because the judge is going to come back to me and ask me if I have any response to it. That's your chance to talk. Jumping up, trying to interrupt the judge, you're just going to irritate the judge. That's not in your favor. Irritating the judge is not in your favor. Let them say what they're going to say. You've got your facts, you've got your evidence, you've got the test. Family court especially is an emotional minefield. It's never easy being in a family courtroom, but because it's your future at stake. Old wounds get opened up. Your ex is creating a big drama that's worked on you before. I'm betting that your marriage was full of the drama that he or she's going to present. You need to keep the judge in your favor. You want to be seen as calm, cool, collected, able to get your point across. The judge doesn't want to hear about what happened in a situation 10 years ago. Doesn't matter today. So what you need to do is breathe, stay calm, focus on your case, and stick to the facts. Staying cool is going to get you much further with the judge and answering their questions. Don't give them a story. When a judge asks you a question, don't give them a story. Answer the question. Even if it's just to say, "No, my lord," or "Yes, my lady." Even if those are the only two words you say. You don't have to give the judge a big long story, and in fact, giving them a big long story only irritates them. If they ask you a question, answer the question. Then you're going to get a decision, either immediately in a regular chambers appearance or docket court, or the justice may even decide to go outside the courtroom and read the affidavits and bring them back in, or you may get referred on to a bigger hearing. The issue's too big for a judge to decide in 10 minutes, and therefore they're going to move it to a bigger hearing. Doesn't matter whether you were in a docket appearance, a chambers appearance, or whether you're heading into a special chambers, an oral hearing, a trial. Be prepared, keep your cool, and stick to the facts. Good luck in court. See you soon.